Good afternoon, everybody. Welcome to our monthly webinar all about your financial well-being. My name is Lori Labrie, and I'm here to talk about payroll-related changes. There's been some significant changes in both payroll laws and in employment laws. First, I wanted to talk a little bit about Schwartz & Schwartz. So we're in the process of celebrating 25 years in business. I think it's great. It's a huge success. And primarily, we focus on healthcare. It was founded originally by Rick and Andrew, but you'll also know that they have an amazing team. I mean, they have 25 employees year-round, and I think most of you work with at least one or two of them. They do payroll, accounting, bookkeeping, and practice management. So, for the whole health and well-being of an individual healthcare practitioner or a healthcare practice. I myself am Lori Labrie. I own Integrated Human Resources, and I'm a human resources practitioner, and I've been open now for 21 years, and I've been working with Schwartz & Schwartz for probably 10 years, handling their human resources and also for some of their clients. In the last, say, 6 months to the next 6 months, we've had more employment law changes than we've had in the entire 10 years prior to this. So our goal today is to cover a lot, but we're going to focus on the Equal Pay Act, which came out in this year. It actually went into effect in July 1st. And Equal Pay Act. Our agenda is to focus on that. It went into effect July 1st. And then also to touch on at the end the non-competition law that's going into effect on 10/1 and also the grand bargain law that's going into effect on 1/1/19. But we're going to focus primarily on the Equal Pay Act. So we're going to cover the wage gap, what comparable work is, any reasons that you can vary wages legally, some provisions that you need to know so you don't go awry, also to create an affirmative defense, because some of you may need that, and then we'll talk about next steps as you go through this law. So the presentation itself, it's not legal advice. There are times when we're going to recommend that you go to an attorney. We are human resources practitioners. We're not attorneys, so you may need to contact an attorney. There is something called attorney-client privilege, which is important in this, and we'll talk about that when we talk about affirmative defense. But we recommend that you use an employment attorney. There's so much happening in employment law right now that with all these laws that we're talking about, it's good to have someone with an employment background put a set of eyes on it. A lot of the other disciplines within law aren't specializing and paying attention to all the nuances of these changes. So the first thing we want to talk about is the law itself. So Massachusetts was the first state to pass wage regulation for gender rights back in 1945. So it's been 70 years. And it actually hasn't worked because we still have women nationally earning 78 to 82% of what men earn. Massachusetts is doing a little bit better because we're 83 to 84%, but it's still a pretty significant difference. What the law says is that employees, all employees, must receive similar pay for comparable work regardless of their gender. So we see different industries that more predominantly one gender or another, and on historic review, the minority gender seems to make a lot less. So this isn't just about women making more, even though traditionally the point above talks about women. There are certain situations where in certain industries men have been making less money. So as we look at the first test, or the biggest part of this is what is comparable work? And in dental, specifically, or actually in any medical, we have to make sure that a position that has to have substantially similar skill, effort, and responsibility. So what's interesting is if I have a larger practice, and let's say I have a practice that has a pediatric component to it, an ortho component to it, and an adult component to it, I could have an assistant, a dental assistant in each one of those areas. And there's a big difference in some ways of skill, effort, and responsibility that's needed. But on the face value, it's really the same position you're assisting. So that type of position is going to take a lot of thought as to how you're going to pay it and how you're going to document it. So the work has to be performed under similar working conditions. So and you'll see in the reasons that we can deviate from the wage law. If I have someone who is working in extreme conditions where a manager is more extreme than another, or if someone's traveling, or if someone's working in an environment that's either higher volume, or there's different components to the fact that we have to have the same working conditions, and we're going to talk a little bit about that in the next bullet point. But the job title and job description alone don't determine the comparability. So just because we have a job description that says, say, assistant or hygienist, it doesn't necessarily mean that everything is equal. We have to look past the job description itself. So working conditions include the environment, so the office itself or the practice, the physical surroundings, what's around them, the equipment they're using, hazards encountered. You know, there may be more hazards in certain types of specialties than in others, and also shift differentials. Are people working different hours, late, early, you know, weekends, if there's any type of shift? I don't believe many practices are 24/7, so it's not like we're working an overnight shift, but there could be some shift differentials in changing wages. So these are the things that they're looking at. These are the tests that we have to use when we determine who gets paid what. The next thing has to do with the pay itself. And what they're talking about with comparable pay is all forms of wages and incentive pay have to be looked at. Now, in this bullet point, I talk about really the incentive side of it, commissions, bonuses, profit sharing, and other production incentives. But there are situations where people are giving non-compensation forms of compensation, if I can say it that way. So we have people that are sometimes getting gift cards, sometimes getting other things added to their compensation that are not put in a paycheck. And that could actually come into play when we're looking at this. So as you write down what everybody's making, you want to make sure that there's other bonuses that people are getting. If you're paying for uniforms for somebody and not for another, that technically could be considered compensation. So as we look at this, we want to make sure we're looking at all forms of compensation. The next bullet point is we can, if I have two people and one is considered now, according to the analysis, if one is underpaid, I can't give a bonus to that person in most cases to clear the fact that they're underpaid and try to make that go away with a bonus. We have to actually adjust the ongoing compensation. We can't just give a bonus. The next component is that we can't decrease someone's pay because of this. That's a challenge right now. Most of you are probably looking for employees and having a very, very hard time getting employees, and we can't decrease someone's pay. Now, right now, we're hiring people at a premium because there's not many people out there. So when we bring someone in, and it could be of a different gender, we might be paying them more solely because we're hiring them in September of 2018 rather than June of 2016 when there were a lot of people banging on our doors to look for people. So as we go through this economic time, we want to make sure that every time we're adding someone, we're making sure that we're looking at who's there and what people are being paid. So if we have to go up $1 on an employee and someone works full-time for us, that's about $2,000 more a year that we're going to have to pay. So, and that's going to have to be for everybody. So if I have, you know, 5 $20 an hour employees and I bring in someone at $24 an hour, we're going to have to look at bringing those 5 employees up that $4. So that's $8,000 a person over 5 people. So that's what this law is asking you to do, is to raise everybody else up. So it's going to come into play with your hiring decisions and who you're going to hire and how you're going to pay people. So it is something that we have to look at. The reasons to vary pay, there is some ability to actually change how we pay people. The first thing is seniority. So seniority is, have you been here longer? Now the issue is, in the parentheses, it talks about without discrimination for a legal leave of absence. So if I'm an employee, let's say I'm a hygienist, and I left, you know, in the last 10 years of my employment 2 to 3 times because I had kids and came back, and someone else didn't do that, and say it's a male that didn't do that, and they have more seniority, I can't be dinged or held accountable for my leave of absence. That is really hard to determine, and I would not want any of you having to find out when an attorney sends a notice to you. But for the most part, if someone has the same amount of time, same date of hire, same position, we have to treat them fairly. There are certain circumstances, if someone's out on, say, a pregnancy leave of absence, a surgery leave of absence, or a medical leave of absence, that we can't ding them for that. But seniority is one of the valid reasons. The other is merit, you know, and this is very subjective in some ways. So merit is, did someone do a better job of it? Is it based on their actual performance? In that case, we really should have some kind of performance documentation to back that up. Right? So we want to be really careful in documenting on an annual basis or more frequently if you're doing that, how someone's performance is impacting the bottom line of the practice and what would make them worth more money to the practice. The next thing is either quantity, quality, or in some cases sales or revenue, depending on what industry or position it is. If someone is producing more, or they're doing a better job and they have less errors, you can pay them more. It's a production-based bonus. We can look at production very easily on most of the dental systems, and if someone is producing more, pay them more. And so I want all of you to get more familiar with the software that you're using, so that if we need that as a way to pay somebody more, we can use that. The next thing is the location. So if we have multiple locations, then we can pay based on the location. The next thing is education, training, or job-related experience. So if people are training and taking courses and continuing their education in a way that's more impactful for the business, then we can pay them more. Job-related experience might get us some, flexibility. If we're hiring someone with some great experience into the practice, we can look a little bit at their prior work experience, and that might be enough to get someone more money in this economy. But we're allowed to look at that. Any type of travel. So I know that there's some that they're going to schools or to jails or to different locations. They're practicing and they're having assistants come with them or hygienists come with them so that they can treat people outside of their office. So if there's any travel or if there's travel to and from locations during the day, we can actually compensate someone more for that travel time. So actually, let me talk about all of these together before I go on to the others. So when you're analyzing your employees and you look at the compensation that you have, I would like to look at date of hire, rate of pay, title, and any of these other varying factors. And it's important to look at where each employee's pay stands to their date of hire, to their position, and to these reasons to vary. And if there's anything that's off of that, we want to make sure that we figure out a reason why we do that, or we're going to have to start adjusting people. I want to talk about some additional provisions in the law because I think that these are going to be important as we go through an analysis. So the first thing is the size of the company doesn't matter. When they rolled out this law, or most times when they rolled out a law, they exclude smaller companies in different sizes, whether it's 6, 11, 15, 25. In this law, it doesn't matter if you only have one employee. We have to apply this law. The next thing, whoops, I went the wrong way, I apologize. The next thing is employees are allowed to discuss wages. Now, this existed already. The National Labor Relations Board allowed employees to discuss wages, but the Mass law is solidifying that. They're calling it out. So employees are allowed to go in a room and talk about wages. We can't give someone a bonus and say, hey, we're giving you this. Don't tell anybody else. We have to allow them to discuss wages. So everything, it's almost as though we're posting it. It's not considered confidential if an employee talks about it with another employee. What is not allowed is if a manager discusses a person's wage with another employee. Okay, so that is still considered confidential. But we have to allow people to talk about it. So everything we do and every change we make, people will most likely know. The next thing is we cannot look at a prior salary history when we're interviewing or compensating someone. In the past, in interviewing, most often everybody's asking, what was your reason for leaving that last position or the position before that, and what did you make when you left there? Because if I have a position that's open for $25 and the person comes in and says, well, I was only making 20 at my last job, I am most likely going to offer them somewhere between 20 and 25, and they're going to be happy. They're making more money, and I'm going to be happy that I'm saving money. So because of that, the law came in and said we can no longer require prior salary history. When we make a decision, we have to look at our position, we have to base it on our position, and we have to have a number. And that's a base number for the person that we're hiring. We can adjust it by the slide we had before for any of those 6 if someone's coming in, but it's basically we're putting a price tag on our position. We can't adjust it based on someone's prior salary history. The next is no retaliation toward employees for exercising their rights. Now, if there's, in our manuals, there's a no retaliation policy. If you don't have one, you should probably have one, because no coworker, no manager, no owner can retaliate if someone says, I deserve more pay, or I was talking to my coworker and I realized they're making more and I should be making more. It is a natural reaction that I see among managers and owners to get upset and to not do whatever that employee is requesting. So the key thing is to not retaliate. No employee, no manager, no owner can retaliate if an employee enacts this law.
Laurie,
Thing that's, yes.
I was just going to ask, are employers allowed to ask people interviewing what they expect or how much they would like to receive?
Yes, so good question. That's Greta. She runs the payroll department over here at Schwartz & Schwartz, and she's phenomenal. Actually, I can tell you, I work with many payroll companies, and I forgot to say this at the beginning, but the Schwartz & Schwartz payroll team is the best of all the payroll companies we work for. So,
Thanks,
yes,
Laurie.
they can do that. So what happens is, if I'm in an interview and say I was interviewing you, Greta, I can't ask you prior history, but I can tell you about the job, and then I can ask you, what would you like to make for this position? That's the only way that we can really ask that. Now, when this law was first coming out, we had a lot of discussions with our employment attorney and with other HR teams trying to figure out how we can get around that question. And the only thing that we came up with, and we don't know for sure until it's litigated, because someone will get sued eventually, and then the court will tell us where that line is. But separate from the prior history and prior experience questions, we then describe our position, and then we ask. And it's not a bad flow, because in the human resources world, if I describe my position first and then I ask them about their experience, they're going to tell me whatever I want to hear based on my position. So when interviewing, ask about their prior experience, then tell them what the position is, and then ask. And if you're taking notes, your notes should be flowing through, and it'll prove that you went in that order. So if we've given them the description of our position, then we can ask them what they'd like to make. Okay. So the 3-year statute of limitations is one of the highest that we have now. So basically, an employee can come back to us 3 years later and file a claim. That's a long time to look back at payroll records. So what we want to make sure of is that all of the documentation stays in place for at least 3 years. Now, it should be because of human resources record retention guidelines, but we want to make sure that employees, because they can come back 3 years later, that we have good, clean documentation about why we gave someone a raise or why we didn't, because we won't remember 3 years ago what happened. So there's now a 3-year statute of limitations, and that's a long time. So telecommuters into Mass are included. Now, this kills me because we have companies that hire people out of other states. I mean, if you look at Alabama, I believe $7.25 is their minimum wage. And there's people that are happy to be making $10 down there. You could hire someone in, say, Alabama that'd log in remotely and do insurance claims for you and pay them, our minimum wage, $11 an hour, and they're ecstatic. But under this law, if I have someone up here in Massachusetts that's making $25 an hour to do that, and I hire another person working remotely in Alabama, that there could be some problems. Now, there is the geographic change and the different location change, but we have to look at that very, very carefully, because specifically it's written in there that telecommuters are included. So if you have people working from home and you start to give them a benefit for working from home, we want to think that through completely, because they could be on the hook. If we say, hey, we're going to hire you, it's not going to be as much because you're telecommuting, that could be a problem. So it opens up a whole different thought process, and they haven't defined exactly what that is yet. So employers are liable for 2 times the wage differential. So what that means is, under wage and hour law, there's a triple damages component to it. Under this law, there's a 2 times differential. So if we had a male who was making $80,000, then traditionally a female in that same position would be making $64,000. So I used the percentages at the beginning of the presentation for this example. But the difference between those 2 wages is $16,000. So if there is a problem and we're deemed to be out of compliance, that $16,000 is going to be doubled. So we would owe the employee $32,000 for that year, plus their attorney's fees. So that's a lot of money going out for a simple mistake. And if we have multiple people, that could be more problematic. The one thing that I believe that this law is going to provide is more class action suits. So if we have a larger group of, say, customer service people or a larger practice with multiple hygienists or multiple assistants, that an attorney could go in to talk to one of the, say, the assistants or the hygienists, and then go back and get the name of all the other employees and take whoever is on the lower part of that range and actually get a class action suit going against that practice. So it's something that we have to think about as we move forward. So the next thing we have is we have something called an affirmative defense. A lot of this is going, the time has passed because we're already in this law, but an affirmative defense says that a company can have certain protections if they're outside of this law, if these things are met. So we can't enact an affirmative defense if we do it when an employee sues us. It's proactive work that companies are supposed to do before we get sued. And it actually technically was supposed to be done before this went into play, but if it wasn't, I would still do it now. So within the 3 years prior to an employee suing us, we have to review and follow these steps. The first thing we have to do is conduct in good faith a reasonable self-evaluation of all of our pay practices. And what that looks like is, in most cases, is an Excel spreadsheet. And it lists who our employees are and what their titles are and what their dates of hire are and what they're paid and any other special compensation that they make. And what we can do is we can group all of our employees and sort them and look at kind of each position and how we're paying people. We can look at by dates of hire and how we're paying people and do an analysis of what people are made. If we find that people are in different genders are being paid differently, then we're allowed to show a reasonable progress toward eliminating this. Now, we can't go fire someone to correct that average, but as long as we're either moving people up slowly over time or we've put in some kind of practice, we're paying people and adjusting wages going forward, at least we're making reasonable effort. Now, the reason why there's a 3-year period is because it is going to take time for some companies to adjust. Now, what I have to confirm is I believe it doesn't start now. This law went into effect July 1st, so the July 1st time, I believe, is the start date on that 3 years. People who started prior to that can do that, but right now we have less than 3 years because we were supposed to start this before July 1st. So as long as we're making reasonable progress, and if after 2 to 3 years we haven't made any changes, that's significant because the first thing is analyzing it. The second thing is making changes. So if we analyze it and we don't make the changes, we might as well have never analyzed it because we have no affirmative defense and we're fully on the hook for the double damages and the attorney's fees. The next thing is we may not be able to pay the double damages if we do have an affirmative defense. Now, the only way that you can get an affirmative defense is with an attorney. So as you're looking at this, if you do an initial review of your employees and you think you have any problems, the first thing you want to do is call an attorney. And what happens is when you call that attorney, you enact what's called attorney-client privilege. So that's one of the things you want to do when you get an affirmative defense is enact attorney-client privilege. And we're going to talk about that when we go over the next steps. So the next steps as you go through this process are we want to take any wage requests off an application. We want to take any, and that includes, in document, online, if you're using any, and I believe now all of the online recruiting websites have changed theirs, but you want to make sure we're not getting any prior wage information. We want to make sure that no applicant or no interviewer is asking anything about prior wages. Right? We want to assess the current pay practices and determine if there's any wage gaps. So if you need to know if there is a problem and you want to set your positions so that going forward you don't have a problem. If you believe you have a problem, and if you want to make sure that you can correct anything, the third bullet point is attorney-client privilege. If there's any issues and you're talking to an attorney about it, every conversation you have is what's called privileged, which means that someone else can't take that information. So as soon as I do a wage analysis, say an Excel spreadsheet, and I realize there's a problem with that wage analysis, if I don't bring in an attorney to review that with me and process it with me, an opposing attorney or any opposing attorney or even an employee in some cases can take that information, and I'm giving them a smoking gun to come back and sue me. So you want to make sure if you're doing this and there's any slight hint of a problem that you bring in an attorney and put that document in any conversations in any education or discussion or decisions under attorney-client privilege. Okay? There is, in the next bullet point, it talks about decreasing another person's wages to close the gap. So obviously we can't go in and say, well, you're making 22 and you really should be at 20, so we're going to decrease you to 20. That's crystal clear that we can't do that. The other thing that we can't do in this case is we can't slow down the increases of another employee and hurt their progression because of the fact that there's a gap. So what they are saying is if everybody in that grouping is getting a 3% increase, I can't give, for no other reason, a 4% to the person who I need to bring up and a 2% to the person I need to stabilize. So we have to have, if we're having any variations in raises and reviews, we have to make sure that we're doing it and we have documented reasons, whether it's performance or volume or the things that we talked about before, making sure that we have a viable reason for making that change. Okay? The last thing is we need to train all of the interviewing managers and hiring managers on this new law, because any misstep could cause a huge problem. I worry sometimes about the industry in general, because we have a lot of, say, hygienists and assistants within a relatively small area in this industry, and the state could come back and say, well, even though I'm having fair pay practices in my office, say here in Woburn, the next town over, they're not, and they may end up coming back and comparing Woburn to the next town over. Now, you probably remember, or most of you remember, if you're owners, there's a sheet that you have to fill out every couple of years, and you send it to the state, and it asks you what titles you have and what wages you're paying. So over time, the state is actually calculating for every position title in every region what people are making. So they have information based on averages to compare what we're doing individually in our own practices against what everybody else is doing in the state. And eventually, as they go to enact more laws like this, or to come after companies for this law, they will have hard data that we don't have access to. So we want to be careful that we don't create a situation where that we're causing some kind of a class action in the industry, which we have seen in other industries. So the payroll change with this law is pretty significant. So we want to make sure that we're analyzing it, that we're making sure that we training everybody, and if bringing in an attorney on it. And as soon as we bring in the attorney, we have that client privilege, because there's a lot of risk to this, and it's hidden risk. So that's something we want to be careful of. Okay. The next law that I want to talk about is the non-compete law. And the non-compete law in Massachusetts just changed. And effective 10/1, so we're right on the cusp of it, it's changed the restrictive covenants that we can enact as an employer. So a business has the right to protect its assets, basically. It has a right to protect its patients, and it has a right to protect its employees and the things that make up any business. What we can no longer do in Massachusetts is say to someone, you can't go work for a competitor. You can't go work at the practice down the street. So most of the non-solicitation, non-disclosure confidentiality agreements at some point said, we don't want you to go somewhere else for a period of whatever the period is. Ours are 12 months. Some of them are longer or shorter. So as of 10/1, we have to change all of the non-compete clauses in all of the agreements. The key thing is, as of 10/1, which is starting basically right now, we have to give people 10 days notice that they are going to be put under some kind of a non-complete, non-solicitation, non-disclosure agreement. So once we take out the restrictions of them working at another organization or starting their own organization, we can still include certain non-disclosures, also the non-solicitation. So they can't take our employees, they can't take our patients, in your case, patients. One of the biggest restrictions or the biggest changes is this last point. It's called garden leave. And what that says is, if I have an employee that works for me and I don't want them to go, up a floor or down a floor, and go work for another practice, I'm going to have to pay them garden leave, which is 50% of their pay for the period of time that I want to restrict their ability to work at a competitor. So if I have someone who's making $60,000 in a year and I want to restrict them for 1 year, that means I'm going to have to pay them half their salary, $30,000 over that year, to stop them from working somewhere. That's what the law is requiring us to do. And so we have to be really careful what verbiage we have in those agreements. We have to be careful what we're doing when we sign off. Now, severance agreements are a little bit different. So there are things that we can have someone sign off if we're giving them cash at the end, but all those agreements need to be changed. And I think as owners, you want to make sure that you're looking at that when someone leaves or when someone's starting. The 10-day requirement is we have to give it to them within 10 days or it could be void or voidable. So that's key. The next thing I want to talk about is the grand bargain. And the grand bargain is something that came almost out of the blue. It feels like it came out of the blue. And supposedly it's better off than what was going to come onto the ballot. But it's changed a lot of what's happening in our world. So minimum wage is now increasing. It's increasing up to $15 an hour over time in the next few years. And it's also providing a paid leave component for, whether it's giving birth or medical, something, and whatever different components, it's getting paid leave, which is significant. Now, the issue is, even though the leave's not starting until 2021, the payroll deductions are starting July 1st of next year. So we need to be ready to do that pretty soon. Depending on the size of your company and what leave it is, the deductions are either paid by the employee or the employer. But you have to understand who's paying what, because we actually have to start those deductions on July 1st of 2019. And we'll work with Greta and her team to make sure they understand so that when you call in, you'll be able to get those questions answered. The other thing is it took out no overtime on Sundays and holidays. And that's mostly in the retail world, but a lot of people specifically worked on Sundays for the overtime. So we'll see how that plays out. But we're not allowed to work overtime. And then the last component of it is the permanent sales tax on the permanent sales tax holiday every year, so that we can, I guess, for the retail industry, it's not necessarily in our industries, but it's allowing that. So those are the three laws that are coming into play. And so we talked today about the non-compete law. We talked today about the grand bargain, and we also talked today. So I am going to actually try to open this up for questions, because I don't know if anybody has any questions. Because right now I am on the phone, but I'm going to open it up, and if anybody has any questions, then we can answer. All right. So you guys now, I believe everybody is unmuted. Are there any questions? Okay, so I have a question in here. How much should the gap be to be significant for this law? Is $1 an hour gap between employees a problem? So $1 an hour on a gap, I guess the size of the gap depends on the wage. So if you have someone who's making, $12 an hour, $15 an hour, $1 is relatively significant. Whereas if you have someone who's making $45 an hour or $44 an hour, it is less significant. What I would do is I would chart everybody and look at that person that's making $1 an hour more. Is there any way we can justify that dollar? And also, what's the gender of both of them? If you predominantly have males in your practice, and that it's the female that's making a dollar less, or if you predominantly have females and it's a male, it's the gender part of this. So on that, I would look at who's making what the gender is, and is there any of. I'm actually going to go back to answer this question. I'm going to go up a slide. I'm going to try to go up a slide. Back to the reasons we can, sorry, it's taking, it's going up each one. All right, so there's reasons, on the screen you'll see the reasons to vary pay. So is there any reason that we can vary the pay? Have they been there longer? Are they higher in production? Is there any location difference? Do they have any more education or experience? Do they have more CEs? Or are they traveling? Okay. So that answers that question. Are there any other questions? All right. Perfect. Then what I'll do is I'm going to go back to the next steps. I'll just go over those once more, and then I will let you guys all get back to work. So the thing that we want to do, your next steps, is to chart out your employees and look at when they were hired, what position they are, and how much they're being paid. And then I would do a data sort to look at the different positions based on gender and see if there's a difference in how people are being paid. If you see a difference, you're doing an analysis from that point forward, and you look at what reason could they be making more. If you determine that there's no real true reason that they're making more, then you would have to technically bring that lower person up, that whatever that difference is, $1, $2, $3. Okay? If it's a very small amount, you can easily correct it in one shot. I don't think you have a problem. If it's any more than that, and you have to really think through how you're going to handle it financially, then I would bring in an attorney, have an attorney look at it with you, so you have attorney-client privilege, okay? And then make sure you're training everybody. So that is all I have for today. Unless there's any other questions, I'm happy to answer those. Or if there's any human resources questions, I'm always happy to answer any human resources questions. So I'll give you guys a couple minutes. I don't see any questions being typed in on the screen. So if there are any other questions, you can let me know. Otherwise, we'll wrap up in a minute. All right. Well, thank you very much, everybody, and have an awesome day.